Hi, I'm Chad DeVeaux. I'm Associate Professor of Law here at Concordia University School of Law. I've been asked today to discuss the Supreme Court's recent decision upholding the Affordable Care Act. I've been following the media coverage of the court's ruling, and it strikes me that there are three prominent misconceptions presented in the media regarding the court's decision. The first one being that most of the commentary on the decision, whether it was a good one or a bad one, seems to turn upon the politics of the person presenting the analysis. That is, people who were inclined to support health care thought it was a great decision. Those who were inclined or opposed to the act thought it was a bad decision. But I think what's lost in that is the fact that the Supreme Court upheld the decision on the basis of a vote of the Chief Justice, whom I think it's safe to say probably personally disagreed with this statute, and voted nonetheless on what he thought as his own interpretation of the Constitution. And whether or not you like the act and whether or not it's a good idea, I think that it's a positive thing that the court has risen above politics and decided this on the merits and possibly against the instincts of the deciding justice. The second misconception that I noticed is that it's presented that the court's rationale has been largely lost in the media. The major issue before the court, at least most of the legal commentators thought the major issue before the court, was whether Congress had the authority to enact this statute under the Commerce Clause, that is, the provision of the Constitution that authorizes Congress to regulate behavior of individuals that cross state lines. And the argument turned upon whether or not uninsured individuals going to emergency rooms essentially created effects that sufficiently cross state lines to justify congressional regulation. The opposition to the statute argued that Congress had never before attempted to regulate behavior in this manner. That is, Congress had never before attempted to enact a law requiring individuals to purchase a commercial product. The court, however, did not uphold the statute on the basis of the Commerce power. Indeed, 5 justices of the court said that the Commerce Clause did not give Congress the authority to enact the statute. They upheld the statute under Congress's taxing power. They essentially held that failure to purchase, that the act did not criminalize the failure to purchase insurance. It did not even suggest that it was not purchasing insurance was an immoral act in any way. It created a choice. Just as one might receive a tax break for putting energy efficient windows in his or her home, the failure to purchase health insurance could be rewarded or punished through the tax code by the government. Now, this distinction between the Congress's taxing power and the Commerce power is important, because if Congress can do this under the taxing power, there's really nothing much else that Congress can do to force people to buy insurance. If the power existed under the Commerce power, Congress could criminalize this behavior, could impose criminal punishment or even imprisonment as a penalty for failure to purchase a commercial product. So while the court upheld the act today, at the same time, the court did limit the ability of Congress to act in the future, and did starkly limit the ability of Congress to enforce this provision through any medium other than the tax code. Finally, the final misconception I would say is that there's been a lot of discussion to the effect that today's ruling was an unmitigated victory for the Obama administration. And I don't believe that's true, because in addition to upholding the so-called individual mandate, the court also made an important ruling with respect to a provision of the Act regarding the expansion of state Medicaid programs. Now, the stated goal of the statute was to essentially reduce the number of Americans. Today there's somewhere between 30 and 35 million Americans who lack health insurance. And the stated goal of the statute was to bring that number down to 0 or as close to 0 as possible. One of the mechanisms through which the statute sought to limit the number of uninsured individuals was to seek state cooperation in the expansion of state Medicaid programs. Now, Medicaid programs are insurance programs run by the state but largely funded by the federal government for certain individuals, for example, pregnant women, children, the elderly, certain specified individuals. One of the provisions of the statute sought to seek the cooperation of the states in expanding these Medicaid programs to include a large number of currently uninsured, low-income individuals. And the federal government cannot force the states to go along with the program, but it sought to encourage them to do that by stating that Any state that declined to participate in this expanded program could face the possibility of the president cutting off that state's entire Medicaid funding. And that's a huge sum of money, which would have huge ramifications for the state. Now this gave the president essentially a very large hammer to use in his negotiations with the states, trying to get them to go along with the new program. Today, the Supreme Court ruled that that provision was unconstitutional. That essentially by authorizing the president to cut off a state's entire Medicaid funding, that essentially amounted to coercion. That it essentially, in the Chief Justice's words, that was the equivalent of allowing the president to put a gun to the head of the state legislature and tell it what to do. And the court said that was unconstitutional. So while the court today upheld the statute, upheld the Affordable Care Act, and upheld the so-called individual mandate, the court did significantly take away the president's chief weapon in terms of dealing with the states and getting them to negotiating with the states and getting them to participate in the new program. And so an important part of the statute, the expansion of state Medicaid programs, that objective may be greatly frustrated by today's opinion. So contrary to what's been said in the media, this is not an unmitigated victory for the president, and the decision may create major setbacks in the future in terms of carrying out the purposes of the statute.